Hi, everyone, and welcome to our webinar, Essentials of Estate Planning, Wills, and Trust, Smart Planning for Today, Tomorrow, and Beyond. According to AARP, only 71% of Americans across all ages have an up-to-date will. Actually, a very famous artist who died without a will or an estate plan was artist Pablo Picasso. When he died, he had a huge estate, many villas, paintings, and a bunch of other assets. But unfortunately, when he passed in 1973, he had no plan. It created a tremendous problem between his family, which is actually still going on today. The two main reasons people don't have an estate plan is, one, procrastination. Everybody tends to put things off to the very last minute. And two is sometimes people believe they don't have enough assets to even warrant an estate plan. During this webinar, which will be led by Attorney Brown, you'll learn why you need an estate plan, challenges and common mistakes to avoid when making one, what happens beyond death, and some trust strategies. My name is Ruby Pellegrin. I am Attorney Brown's legal assistant and office manager. And I just want to go over the platform for you guys before I pass it over to him. If you look on the left side of your screen, you're going to see a little area that has Q&A, polls, and handouts. Under handouts, you'll see that we have provided some educational handouts for you. One is how to avoid probate, which Attorney Brown will go over with you. And we also have a little estate plan quiz for you to download to see if making an estate plan is right for you. Furthermore, if you look down to the left bottom of your screen, sometimes you'll see a little pop-up box that says schedule a complimentary consultation. They'll actually link you to our website where you can, in fact, schedule a complimentary consultation with Attorney Brown. And now I shall pass it over to him.
Thank you, Ruby. I appreciate it, Ruby. So who am I? Well, I'm a certified specialist in estate planning, trust, and probate law. I've been a certified specialist since 1993. I'm also a VA certified attorney, which basically means I can assist with veterans and their spouses in receiving some benefits such as aid and attendance. One of the things I want to emphasize is estate planning is more than just planning for death. It's planning for incapacity, and we're going to talk about what's called elder law planning. I've been an attorney since 1986. I have about 34 years of experience, and over that time period, I estimate, over 6,000 estate plans. Our practice is limited to estate planning, but it's more than just trust or wills. We do basic and advanced planning. We do trust administrations, more than just death, but also during lifetime. We also deal with probates, which we're trying to avoid. And once again, as Ruby said, we have a workbook that you can download, how to avoid probate. We are dealing, with a lot of families these days that are called blended families. And how do we preserve the assets for a deceased spouse's own children? So we'll talk about that, on a one-to-one situation. We do asset preservation. If somebody becomes incapacitated and we're spending all the assets on the ill spouse, what do we do for the healthy spouse? That's what the elder law is all about. As part of elder law, we do Medi-Cal and VA planning. We also do some charitable gifting for clients. We talk about, what your options are. And we also talk about gift and estate tax planning and when to make a gift. There's something called a step-up in basis, and sometimes it makes sense to make gifts during lifetime, and sometimes it makes sense to make gifts at death. So basically, we're conveniently located in Carlsbad, California. You have myself. We're definitely a full-service estate planning office. We're not just saying, here's a document, goodbye. We want to help you. I have an associate by the name of Eric Cha. I also have my legal assistant, Ruby Pellegrin, and my legal assistant, Liz Mendoza. So who am I and my family? Basically, I've been a resident of North County of San Diego for over 55 years. I've been married for 26 years. My wife's named Rebecca. We kind of have the yin and yang because as a estate planning lawyer, I'm dealing with elderly people and those who pass on. My wife is a midwife at UCSD Hospital, so she's delivering babies. She's estimated, actually, she's over 2,650 babies she's delivered. I have a son named Alex. We'll talk about him later on. And he attends SMU College in Dallas, Texas. He's going to turn 20 this month. But to give you the full picture, so my wife births babies. My mother was a wedding coordinator, and basically she married people. My father was a divorce lawyer and basically divorced the people, and finally I deal with all the aspects of life and basically help you transition to the next stage after death. So when we talk about estate planning, we got to break it up. What's an estate? And people say often, I don't have an estate. What do I care? Well, if you got 50 cents in your pocket, it has to go somewhere. So we're going to talk about that. So really, an estate is all the wealth you've accumulated during lifetime as well as at death. And some of us are worth sometimes more at death than during lifetime. Sometimes you have life insurance. We got to basically have a plan as to what to do with that. So estate planning is who needs it? Well, by law, anybody over age 18 can do one. And I will make one comment. My son, when he turned 18, one of the first things I did was to do a last will and testament for him, as well as a financial power of attorney and healthcare power of attorney. Because as a parent, he was no longer a child, and so we could not speak for him. Do you have any assets? How's it go to him? How's it goes to my wife? If you have any real estate in California, you want to avoid probate. And if you have real estate in California, you have a probate. You have real estate out of probate, you have a second probate. You have more states. Each state we have real estate will be a separate probate. And if you have minor children, it's critical to basically have an estate plan to catch those assets. Because if you pass away and you have a child under 18, he gets it at 18. And that's usually way too young for most people. My minimum age is usually about 25. And so basically, I'd like to make sure that it's held in a trust until at least 25. So estate planning is more than just planning for death. Once again, it's the creation of your wealth. It's the preservation and the final distribution. So you worked hard for a living, or you're working hard for a living, and now someday you want to retire. And you want to preserve your assets for your entire life. How long would that be? Who knows? My oldest client passed away a couple years ago at 100 age 13. I saw her for about 20 years before that. And basically we helped her. We had her daughter come on in and basically became a co-trustee to make life a little bit easier. So basically I find myself into preservation more, how to preserve assets through Medi-Cal and VA planning. There's a number of things we can do to help preserve what you have. And then ultimately, and finally, we want to pass the estate down to your intended heirs, spouse, children, etc. So what are the goals and objectives of estate planning? The who, the what, the when, and how. That's what we address. That's how we help people. Who will receive your assets? Basically, that's pretty clear. I have one wife. It goes to my wife. If she's not alive, that goes to our one son. That's really easy. But he's 18, going on 19. So he's actually 19, going on 20 this year. I apologize. So basically, I do not want him to get the estate until a certain time period. So basically, the when question is that when do I think it's appropriate? And I said my default is 25, but I think in my practice, I think I changed my trust to say half at 25 and half at 30. But he's under 25 right now. Who will manage the estate? If I pass away, it goes, my wife can do it. But if she's unable to do it, who steps in? I don't want my son to do it right now. So we got to figure out. It should be a sibling. Should it be a corporate trustee? Should it be a private fiduciary? These are people that will step in and help you when you can't do it yourself. So the challenges of estate planning. What are the challenges? Well, if you don't do the estate planning properly, you're going to find not one attorney involved. You're going to find multiple attorneys. And the fees don't double up when you have two attorneys. They kind of triple or quadruple at least. Then we have the issue of probate. So basically, you really want to avoid the courts. Who wins when you go to court? Not the family, it's the attorneys. We have issues regarding estate taxes. Will there be a death tax on your death when you pass away with regards to your assets? What happens if you need long-term care? What happens if you become incapacitated? Who's going to help you when you can't do it yourself? We'll talk about this. But if you don't do it properly, you're going to have another big challenge. It's going to be the family. You really want to avoid having the family squabbles. You want to make sure your estate planning is your current goal and objective. So the common mistakes is, and Ruby said this earlier, procrastination. That's the human nature. I'll do it tomorrow. I'll get around to it. And that doesn't happen. So basically we have to overcome that if we can. We want to have some of you who have done estate plans to make sure they're current. That's another form of procrastination. You may have nothing, but you may have something that's even worse than having something. When you do estate planning, it's really two parts. You got to create the bucket if you're doing a trust. And what do you do with this bucket? You got to transfer assets into the bucket. So it's critical that you have the title of your assets in the way that will avoid the probate. Now, some of these issues deal with wrong beneficiary designations, some IRAs and life insurance and 401ks. And basically what we want to do is make sure that it's proper. I had a client that normally you would not probate an IRA and an annuity, but what happened was that she had an elderly aunt as her primary beneficiary. And I emphasize elderly. Guess who died first? The elderly aunt. Then she had nobody. Well, that's not quite true. She had the default rule, which is the estate. That means we had to probate and find her next of kin. The other thing is that you got to find someone who's going to manage your affairs. Right now, I feel very uncomfortable about having my son be my trustee. I think eventually he'll get there. He's impressing me, every day a little bit more. But right now, he's not there. So basically, you might have the wrong trustee or executor. And that person may have been the right person at the time you wrote your document the first time, but maybe they moved away. Maybe they moved to Europe. Maybe they're on the East Coast. Maybe they have financial problems. You got to keep things current. And lastly, if you have no estate plan, because that's kind of a misnomer, because you do have one, and you really don't want like the default if you don't have a estate plan and you become incapacitated. So what happens is basically, have you planned for incapacity? Clients 30 years ago used to say, if I die. Clients today are pretty smart. They don't say if I die, they say when I die, but they say if I become incapacitated. And really the numbers over a certain age are pretty impressive. Unfortunately, over 85, it's about 50% of people will need assistance. So what you want to do, and once again, I'm going to go back to my workbook because it says how to avoid probate and conservatorship. And the conservatorship is the process, if you have nothing. So basically what happens is that you go into court, and the courts will appoint somebody to look after you and basically handle your personal affairs as well as your financial affairs for your lifetime. And then finally, on your death, it goes to probate at that time. So what can you do during lifetime? Well, for healthcare issues, you can have a living will or a document we call a POS, physician order for life-saving treatment, and basically put your wishes down. And most clients really do not want to be kept on artificial life support systems when there's no chance of recovery. But we can draft a better document than that, in my opinion. We can do what's called a healthcare directive or an advanced healthcare directive that allows someone to step in your shoes to act for your body needs. And you spell out your wishes, and we can customize this for our clients. And basically, you can have one person, maybe a spouse, maybe somebody else. You can then have a son or daughter. You can have a number of people. So if the first one can't do it, then the second person can do it, a third person. But now you put things down in writing that says, if I need it, I'm going to appoint somebody to look after my personal body needs. So you'll be aware of what's called a DNR for, do not resuscitate. You do that through your doctor at the hospital typically. It says, do not keep me on life support systems. But who's going to talk to the doctor on your behalf? That's going to be your agent under your advanced healthcare directive. So that's your healthcare. What about your financial? Well, basically, there are a number of documents or a number of ways you have things. You can have a joint ownership. You can go down to the bank, open an account, have some assets in there, and basically allow a spouse and or a son or a daughter to have access to your funds. I don't mind doing that for small amounts, but for your larger assets, I don't care for that so much. But at least have something there. Probably what's better is what's have a financial power of attorney, a durable power of attorney. It means lasting. If you become incapacitated, it allows someone to act on your behalf when you cannot do it yourself. And once again, it deals with assets, estate management tool. It's a great tool. But probably a little bit better is a living trust. Why? Well, power of attorney is only good while you are alive. Then it stops. It doesn't work afterwards. The living trust helps you not only during lifetime, but in death as well. And allows you to pick someone to be your manager, your trustee, to step in your shoes when you cannot do it yourself. And still avoid probate. Issue we have to deal with is long-term care. What happens to you in your estate if you need long-term care for an extended period of time? Well, one option would be to stay at home. Maybe you have enough assets to take care of yourself, and that's fine. Maybe you need to go to a skilled nursing facility. Maybe that makes sense depending on your situation. Maybe what's called a boarding care facility. Maybe you move in with a son or daughter. I will admit to you that my dad, the last 2 years of his life, lived with me. It was kind of interesting because he was a fellow attorney. We'd have our interesting legal debates, but we made up as good father and son afterwards through the day. Private pay, how does it get paid? Long-term care insurance is one option. Some people are looking at reverse mortgages, and some people were looking at what's called Medi-Cal planning, some say called Medicaid, and we look at veterans benefits, which may be aid and attendance. So what happens when you pass away? Well, basically, the first question is there going to be a death tax? Under current law, most people will not have a death tax. The exemption amount for 2020 is $11,580,000. So most people will not have an estate tax. If you're under that amount, you won't have it. If you're married, you can double up now. You can have $23,000,000 $160,000. But that number will change next year, and that number does change in the year 2025, or actually 2026, if Washington does not change it sooner. What are we trying to avoid? Once again, my workbook, how to avoid probate. We want to not have court. So basically what happens at death, general rule is if you have no documents, you have a will, you are headed to probate court. What's probate? People say, I have a will. I thought I avoid probate. No, probate is the administration. It's the distribution. It's the passing of your assets or estate by a court pursuant to the terms of your last will and testament or by the laws of intestacy. That means if you don't die, you die without your own personal will. Here's some facts for 2020. Probate is expensive. If you go to my workbook on page 3, probate is based upon the gross value of the estate. What's that mean? You add everything up. The house, the car, the stocks and bonds, the furniture, appliances, you get a top dollar value, and you do not subtract for encumbrances, liens, and debts. And basically, you have the gross value. On $1 million, the gross, the value of the expense is going to be $48,000. Now, half goes to the attorney, $24,000. The other half goes to the executor, $24,000. There's filing fees, publication fees, some other miscellaneous expenses. And basically, we're looking closer to $50,000. Who is normally your executor? If it's a spouse and they're going to get it anyway, they'll waive their fee. Why? Because come April 15th, there will be income taxes on that. So most people will waive that fee because they don't want the taxes. Now, not all estates go through probate. If your assets are below $166,250, then you will not go to court. And there's some simple documents you can prepare to avoid the process of getting assets that may be in a bank or a brokerage account. It does take time. We're looking at about a minimum of 1 year or more. And basically what happens here is that you have to file the petition. You got to give notice out there. And I'll be honest with you, with COVID these days, it's been taking a lot longer right now. And so basically what we're dealing with is we're doing court online these days or through the phones, more or less at this point. But it's still a very private, there's no privacy in the probate. It's open court. And basically what happens here is that anybody can find out who died, go to court and find out, who your spouse was, who your children are, what kind of debt you have. Because how do people find people died? They read the obituaries. So they go to San Diego Union, they go to the obituaries, and they find out who died. Then they go to the court's website and find out who you are, your spouse, your children, your debts, your assets, etc. What's really interesting to me is that I could be in northern Maine. Now in northern Maine, I can look at the San Diego Union page and see who died and do the same thing. I can find out everything about you. So it's kind of worldwide these days. So here's the basic techniques to pass your estate. You can die intestate. You can die with a will. You can die with jointly held property. You can die with living trusts or some kind of contract. So if you die intestate, how do you die? That means you die without your own personal document. Does that mean you have a plan? You actually do have a plan. The state of California says if you don't have your personal one, we're going to presume you like our plan better. And if you got community property, you got a spouse, it goes to your spouse. If you have separate property, part goes to your spouse, part goes to your kids. You have no spouse, it goes to your kids. You have no kids, it goes to your grandchildren. If you have nobody below you, it goes to your parents. You have no parents, it goes to your siblings. No siblings, nieces and nephews. See, there is a plan. And if you have nobody in your family, that's actually, you have the state of California calls escheats to the state of California. You still got to go to court. It takes fees and taxes and time to do that, even though you have no personal document. I'm going to recommend that you have at least a simple last will and testament. You're going to waive the requirement of bond. You can spell out your desires. And it's fairly inexpensive. The least expensive last will is called a holographic will. What does that mean? What that means is that you've done it yourself. And California allows holographic wills. Not all states do. And you take a piece of paper, and you can take a piece of, you can take a pen or a pencil and spell out your wishes. And the thing that you have to do is to sign it. Now, some people think you need to date it. No, you don't. But I still like that, have it dated. Why? Because if you have two holographic wills and they're both undated, which one to use? The answer is the latest one in time, but how do you prove that? So basically, you really should have them dated at that point. Now, some people with computers these days think it's better, and they type it all out, then they'll sign it. That won't be valid because you need two witnesses now. So if it's typed out or if someone else writes it out for you, it's got to have two witnesses. So you could have jointly held property. So basically, two strangers can own property together, or basically, you can have a bunch of people as joint tenancy. So if one dies, it goes to the other ones. Everybody dies except for one person, then now it's delayed. Probate goes at that point. But I'm going to recommend, it's not uncommon for a husband and wife to have joint tenancy. But they should really have, especially in California, what's called community property. They should have what's really called community property right of survivorship. And so what happens here is that there's great tax benefits when one spouse dies in a community property state who are married. When one spouse dies, the basis gets stepped up to the current fair market value. What does that mean? Let's say you pay $10,000 for something, and it's now worth $100,000. So the appreciation is $90,000. So under community property, if a spouse dies, the whole thing gets stepped up from $10,000 to $100,000. Surviving spouse can now sell it. They will be paying capital gains. Capital gain rates on the federal level is about 20%, and the state of California is 10%. So that's 30% or a third. So a third of 90,000, roughly 30,000, would go to Uncle Sam if you did it before you died. But if you waited for the first spouse's death, then we can wipe away those capital gains and then readjust it at that point. So contracts. You know, a typical contract is like a life insurance. It's supposed to pay out upon a certain event. What's that event? Death. You have a life insurance policy on yourself. You die. It has a beneficiary. Who's the beneficiary? It could be a spouse, could be children, or it could be the living trust is what I recommend. And why do I recommend that? It's actually that if you're driving down the street and you're married, you get in a car accident, you die, and your spouse is in a coma, who makes that claim for the life insurance? Well, it's in the trust. The next trustee steps in and takes the claim on that. On annuities for tax reasons, I tend to recommend if you happen to have an annuity that you have spouse first, children second. Why is that? A spouse can roll that annuity into another annuity and avoid the tax until they're ready to pay it out. If you have a pension, I must admit, I'm very envious if anybody has got a pension. Why? Because we don't see too many more of these. Your pension will more than likely stop at your death, or if you're married, it will continue with your spouse and then stop at that point. IRAs, 401ks, basically what happens here is that you have a beneficiary, typically your spouse first. They get to roll that over into a new IRA or a 401k, same thing. But if you have your children on there, the rule just changed this year under the Secure Act, basically saying that they do not have the life expectancy that they had before to pull it all out. What that means? So you have a child that's 40 and they have another 40 years to live. They can pull out 140th, 139th, 130th, etc. But actually, the new rule is now they have 10 years to pull that out. So if you have a rather large IRA, then they have to pull out the whole thing within 10 years. You may have a simple account down at the bank that says, you know, your name. I would probably recommend having POD. POD means paid on death. You can go to the living trust, could go to somebody else, could go to a child or your spouse. So you can have bank accounts that go automatically to somebody else. I'd also suggest maybe at small amounts of money, I don't mind what's called TOD. What does that mean? TOD stands for transfer on death. And so you could do that with securities or the car. I like my clients to say to me, Arthur, I want my car to go to a particular child. Very easy. You can go to the DMV or AAA and have the registration changed over to your name, TOD, that child's name, at your death. It's very easy to get access to that car after your demise. So we're here to talk about strategies to avoid probate. And basically what we tend to use is what's called a living trust. What is a living trust? Well, basically, a living trust is a legal arrangement which allows you to maintain control of your assets during your lifetime. And if you become incapacitated, have somebody else step in and take care of you during lifetime, and then pass these assets at your death to your intended beneficiaries without the need of probate. So basically, there's more than one type of trust, and there's what's usually known as revocable trust and irrevocable trust. What's a revocable trust? This is the foundation of most of my clients' estate plan. It's a trust that can be altered, amended, or revoked. What's an irrevocable trust? A trust that cannot be altered, amended, or revoked. You can't make changes. And there's reasons why you use one over the other, and it depends on each situation. So it's important to talk, what is your goal and objective? What do we need to accomplish? And sometimes clients start off with a revocable trust, but down the road, as their events change due to their health sometimes, we may go into an irrevocable trust. So who are the parties involved in the trust? Well, the creator of the trust, the one who sets it up, it's called a settlor. Some lawyers use the term trustor, means the same thing. Who manages your affairs during lifetime when you're competent? You do, and so you are the initial trustee. Who gets the benefits while you're alive? You do. You are the life beneficiary. These assets are put into a trust. If you become incapacitated, then a successor trustee steps in, provides for you during lifetime, and then following at your death, the assets go to your remainder beneficiary. Maybe that be your children at that point. So who is going to be your trustee? This is a very important decision you have to make. I have a number of clients who have no spouses and they have no children, or they don't have their husband and wife only, but there's nobody else. So we have to really figure out what's the best person. A trustee can be a family member. As I said earlier, maybe I think my son will be ultimately my trustee, but he's not quite ready to be that. So it can be a family member, spouse, children. I'm not a big fan of friends and neighbors down the street. There are people called private fiduciaries. Their job is to take care of you during lifetime. That's their profession. And so they are registered, and basically we can introduce you to a number of them if you need some assistance here. Or some banks, not all, and some credit unions have what's called a corporate trustee. And basically they are a company that will be in business upon your death and take care of you during lifetime as well as death for your intended beneficiaries. So here's really a simple, smart living trust. You take the assets and you put them in the trust. And then we take a snapshot at death. How large is the estate? Today, if it's over $12 million, you have to pay estate tax. But if that exemption amount goes back down to $5 million, 3.5, there's talk about that. There may be an estate tax on your demise. Right now, there may not be, but in the future, there may be. So we have to see what happens back in Washington. And then ultimately, without probate, it's going to go to your beneficiaries. So basically, you do planning. As the law changes, you come back in, we modify it, and basically keep you up to date and keep your goals and objectives current. So basically, as I said, we do more than one type of trust. There are other trusts such as simple disclaimer trust or Q-tip trust. There's a blended family trust. There is skip generation trust, or what's called GST trust. You want to hold the assets in trust during your child's lifetime and ultimately go to the grandchildren. Sometimes we do a life insurance trust. Sometimes we will do a charitable remainder trust. We do a Medi-Cal trust that for those clients who become incapacitated or have a spouse who's going to become incapacitated. And depending on the situation, we'll have to find what's most appropriate for you. So one of the things is that when you do estate planning, it's more than just a trust or a will. It's a comprehensive plan. It all has to work together. And what happens here is basically you need a living trust. You still need a will, but it's called a pour-over will. And what happens here is that basically those assets that are in your estate, and hopefully well below $166,000, basically can go in the trust after your demise quite simply. You need to have what's called a durable financial power attorney. Durable means lasting. If you become incapacitated, then your agent steps in, takes care of you during lifetime as well for your financial matters. You also need an advanced healthcare directive. And these all work together. We'll show you in the next slide how it's done. You need an assignment of personal property that sweeps it all into the trust. And we also have a property agreement that if you're married, then it allows it to be changed over from joint tenancy or separate property, depending on what you want, to community property. So how does it work? Well, in my handout in the workbook on one of the pages, it says how this works for a husband and wife. And if you delete one person, you kind of see how it works as well. So typically on a husband and wife, we'll do a community property agreement that says whose assets are whose, or if they're theirs together. We want to do an advanced healthcare directive. It says, do not keep me on life support systems. We also want to do a financial power attorney. Someone steps in because not all the assets go in the trust. What doesn't go in the trust? An IRA. If you put IRAs into a trust, it's a taxable event. So you have an agent of the power attorney that can basically instruct your custodian as to when to distribute money out. We also want to nominate a conservatorship, even though we're trying to conservatorship, we're trying to avoid this. You need to create a trust. But once again, it's two parts. You create the bucket, then you need to transfer assets into the bucket. So that's your house, your assets, securities, and cash, etc., into the trust. And while you're alive, you're entitled to all the income as well as the principal for your lifetime. Now on your death, what happens? We have what's called a pour-over will. That will takes care of those things that are not in the trust and basically passes out to your living trust. Then ultimately those trust assets go down to your remainder beneficiaries, your children typically at that time. So where do you go from here? This is a lot of information. It's done quickly. Well, one of the things you can do is keep in mind that you want the peace of mind to avoid probate. And once again, my workbook talks about how to avoid probate. How do you create your own personal plan? Well, first off, you might do human nature and say, I'll do it tomorrow, or I'll do it later. You can do it yourself. You can do all this research and try to figure out what is right, what's appropriate. But I've been changing my documents for 33 years. I'm still trying to keep them current. I go to many seminars, and basically what's happening is I keep things current as what the law changes. You can work with others. Be careful in working with others. Some people have the intentions of trying to sell you products and not really do a trust for you, and it might seem really low. You really want to have someone available. You know, Arthur, you did my trust 5 years ago. I got a question for you. Yes, I take the question and I answer it for you. What I recommend is that don't work with others, but work with us. And basically, once again, we are conveniently located in Carlsbad, California. We're a small and efficient team. We're just not we don't have a lot of numbers of clients out there. We do provide a complimentary consultation. And Ruby's going to talk about the call of action and take advantage of that as well. But we want to hear your goals, your objectives. You may have a document that looks fine on paper, but once I start talking to you and you're telling me what you want, it may not be the correct plan you want. We want to make sure that your goals and objectives are current. Now, typically what happens here is that, you know, we have appointments, and we have basically 3 or 4 appointments depending on the client's needs at that point. And our fees are approximately $3,400 to $3,600. We do give a discount for those who attended the workshop. And basically, I usually deducted $200, half an hour of my time, basically, from the overall cost in order to say thank you for coming in. And I don't need to teach you about estate planning because you just heard about it. With that in mind, what I want to do is pass it on to Ruby, and we have some cautions out here, and she'll talk about those as how we're handling the COVID issue in my office. Thank you.
Thank you. Hello, everybody again. Thank you again so much for attending our webinar. I hope it was both informative and beneficial for you. Again, as Arthur mentioned, please go to the handout section and download his book of How to Avoid Probate. It's such a great tool for you to use for the future and now. Also on that handout, you'll find our confidential questionnaire, which is what we would ask you to come to fill out if you would like to take advantage of that complimentary consultation. We just ask you to fill it out to the best of your abilities and bring it in during that consultation. And this way, Arthur can, Attorney Brown can tailor the estate plan for you specifically. And like he said earlier, since you're already educated on what estate planning is, now during this consultation, it's more focusing on you and your goals and objectives. We are accepting in-person appointments. Again, with COVID happening, we've been taking many precautions on it. For example, we have stretched out our appointment times. We only have selected appointment times for clients. That way, when they're in office and leaving, there's no overlap. We've changed out our very beautiful and comfortable leather chairs for some very nice stainless steel chairs that we can sanitize for you guys before coming in. Our lobby is closed. That way there's no other contact or contamination. And we all wear facial coverings during the duration of the appointment. I will be reaching out to you guys shortly after this webinar. Again, thank you so much for joining us. And if you have any questions, you can ask them on the Q&A side of the screen, and they are private, so it will come directly to us. Nobody else will see that, and I will reach out to you and answer those questions personally. If I cannot, then Attorney Brown will reach out to you himself. Thank you so much, and have a great day, guys.